Pursuant to House Resolution 228, the gentleman from Texas, Mr. Weber, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Texas.
Thank you, Mr. Chairman. I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Chairman, thank you for recognizing me to speak in favor of my amendment on this very important legislation. I want to thank Mr. Terry for leading on an issue that is crucial to our economic recovery and our energy future. Rather than wait around for further delays, 1,700 days and counting, and excuses from the President, Mr. Terry has taken action to deliver the jobs and energy security that this administration so frequently promises to the American people. Last week marked 1,700 days. That's 4.65 years since the first permit application was filed for. Now, let me put that in perspective. I have a granddaughter that will be 2 years old in July. Had she been born when this permit was filed, she would be entering kindergarten this coming fall. Her name is Kate Liberty, by the way. She's the cutest thing this side of the Atlantic. During that time, the State Department has produced, as the whip said, over 15,000 pages of environmental impact assessment, which have been endlessly discussed, debated, and deconstructed. Hundreds of thousands of public comments were made on these documents, and public meetings were held across the country in multiple states. However, in 2012, President Obama rejected the first permit application for Keystone XL pipeline, claiming that the deadline which required him to make a decision prevented a full assessment of the pipeline's impact. I would conclude, and I'm sure most of you would agree, that the State Department study of Keystone XL has gone far and above and beyond the threshold required of a, quote, full assessment, end quote. In fact, this unprecedented degree of scrutiny has led many to conclude that the Keystone XL is the most studied pipeline in our nation's history. Despite this exhaustive environmental review, the administration has yet to make a decision on a project that will create American jobs, stimulate the economy, and enhance our energy security. In the meantime, opponents of the project continue to rely on false assumptions and misconceptions to urge its rejection. My amendment simply sets the record straight on these accounts by adding findings of our own State Department that attest to the safety and environmental soundness of this project. There are those who oppose the project saying it hasn't been studied enough. That's laughable. That we are proceeding hastily. 4.5 years, really? 4.5 years and 15,000 pages prove otherwise. Others allege that the pipeline is a safety risk. The State Department findings prove these allegations unfounded. In fact, the State Department concluded that it has 57 extra safety features, and with that, the Keystone XL would have a degree of safety over any other domestic pipeline. There are those who try to argue that the pipeline would threaten water resources, wildlife, and the communities along the route. However, the State Department disagrees, concluding that there would be, quote, no significant impacts, end quote, to resources along the proposed route. Some insist that the pipeline will lead to increased greenhouse gas emissions and that halting the project will somehow combat global warming or reduce carbon emissions. However, again, our State Department's estimates of incremental emissions associated with the project are marginal and would have negligible impact on climate change, if any. Moreover, the State Department concluded that Canadian oil sands productions will continue regardless of whether or not we build the Keystone. A global oil market and the statements of Canadian officials reinforce this reality. The science supports approval of Keystone XL, and I agree. Given the facts, I see no reason the administration should make the American people wait any longer for a project whose construction will support up to 40,000 jobs and generate $2 billion in earnings. Thank you, Mr. Chairman. I reserve the balance of my time.
The gentleman from Texas reserves. The gentleman from California, for what purpose?
Mr. Chairman, I rise to take the time in opposition to this amendment.
The gentleman from California is recognized.
This amendment selects some statements from the State Department's draft supplemental environmental impact statement to try to suggest that the Keystone XL tar sands pipeline poses no threat to the environment. I only wish that were the case. This is a matter of basic chemistry. Tar sands don't contain oil. It takes a lot of energy to melt and process the tar sands into something that we can use like oil. That extra energy means more carbon pollution. The State Department estimated that a gallon of gasoline from tar sands is responsible for about 17% more carbon pollution than the average U.S. gallon of gasoline. And it estimated that shifting to tar sands crude could add as much U.S. carbon pollution as 4.5 million more vehicles. Not surprisingly, these findings are not in this amendment. But the real problem with this amendment isn't what it leaves out. The real problem is that it tries to argue that the Keystone XL tar sands pipeline does not pose real and serious environmental harm, and that's dangerously wrong. The fact is, we may be able to avoid the worst consequences of climate change, or we may be able to fully develop the tar sands without capturing the carbon, but we can't have both. And building Keystone XL is critical to oil companies' plans to triple production of the tar sands. The State Department's review rests on a key assumption. They assumed that if Keystone XL isn't built, the additional tar sands production would be moved by rail. They also assumed that the extra costs of rail wouldn't be high enough to affect investments in new tar sands projects. With all due respect to the State Department, this is one case where many experts think they have just got it wrong. A recent Reuters report found big flaws in the State Department's analysis. Among other things, State assumed that rail shipment would cost about $10 per barrel, but current costs are closer to $30 per barrel. The former Alberta Energy Minister said, "If there's something that kept me up at night, it would be the fear that before too long we're going to be landlocked in bitumen," end quote. A Deloitte report said, quote, "Unless key transportation challenges are overcome, that new oil will have nowhere to go," end quote. And here's TD Economics, quote, "Production growth cannot occur unless some of the planned pipeline projects out of Western Canada go ahead," end quote. And here's what AJM Petroleum Consultants have said: "Unless we get increased market access, like with Keystone XL, we're going to be stuck. Our production is going to be the one backed out of the system." And here's what the former editor of Oil Week said: "Essential to diminishing hopes for an oil sands bonanza are three proposed pipelines." The Canadian Energy Research Institute said, quote, "With Keystone XL in place and operating at capacity, bitumen production could increase substantially," end quote. Keystone XL pipeline is the key to enabling a massive increase in tar sands production and locking in our dependence on this very dirty oil. This would be catastrophic for the climate. This amendment tries to downplay the climate impacts of Keystone XL, but even under the State Department's flawed analysis, there isn't another project in America with bigger climate impacts. I urge a no vote on this Weber amendment and on H.R. 3, and I reserve the balance of our time.
Gentleman from California reserves. Gentleman from Texas.
Mr. Chairman, how much time?
1 minute.
1 minute. Well, I appreciate the gentleman from California's comments. It's interesting that we are going to belie the State Department's assessment when it's advantageous to the argument, but we're going to try to rely on it. I'm sorry, when it's not advantageous, but try to rely on it. It's admirable that he's concerned about the cost per barrel of bitumen. I own a small business, and by golly, the oil companies that produce jobs and wealth for this company will decide on whether it's too costly. The previous gentleman from New Jersey said there was no proof that even the oil would stay here in this country. Well, I submit to you, Mr. Chairman and esteemed members. To what company do we say we don't want you exporting your products? Do you tell Nike that? Do you tell Ford that? Who do you tell that? And then to his statements that it's going to increase greenhouse gases, experts have done the math and they come up with, if at all, it raises 1/100,000th of a degree Fahrenheit in global warming. And finally, we heard testimony from the experts in our hearing, saves 400 to 500 trucks a day off the highway, Mr. Speaker. I yield.
Gentleman's time has expired.
Reserve the balance of my time.
Gentleman's time has expired. Gentleman from California has 30 seconds.
Mr. Chairman and my colleagues, the issue is if we don't build this pipeline, can those tar sands oil be trucked? Can they be taken to market? And I submit that if we don't build these tar sands pipeline, they're not going to be able to afford to truck it anywhere else. They're trying to get us to help bail them out with this dirty tar sands oil so they can use the United States to help Canadian oil production, and we ought to say no.
Gentleman's time has expired. The question is on the amendment offered by the gentleman from Texas. Those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the ayes have it. The amendment...
I request the yeas and nays, please.
Does the gentleman ask for a recorded vote?
Yes.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Texas will be postponed. It is now in order to consider Amendment Number 2, printed in House Report 113-88. For what purpose does the gentleman from California seek recognition?
Mr. Chairman, I seek recognition in support of the amendment.
The clerk will designate the amendment.
Amendment Number 2, printed in House Report Number 113-88, offered by Mr. Waxman of California.
Pursuant to House Resolution 228, the gentleman from California, Mr. Waxman, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from California.
Mr. Chairman, this month we passed a grim milestone. Scientists recorded atmospheric concentration of carbon dioxide of more than 400 parts per million. The last time carbon dioxide concentrations were at that level was 3 million years ago. Seas were 60 feet higher, and human beings did not even exist. This milestone is yet another urgent reminder that we need to take immediate action to build a clean energy, low-carbon future. The Keystone XL pipeline takes us precisely in the wrong direction. This pipeline will expedite production of the dirtiest and most carbon-intensive crude oil on the planet and lock in our dependence on this dirty fuel for decades to come. I'm strongly opposed to the Keystone XL pipeline for that reason. But if the House is going to pass a bill that approves the Keystone XL pipeline, the least we can do is try to minimize the harm. That's the point of this amendment. Tar sands don't contain oil. It takes a lot of energy to melt and process the tar sands into something that we can use like oil. That extra energy means more carbon pollution. This isn't in dispute, although we hear arguments that it is, but it is not in dispute. The State Department has estimated that a gallon of gasoline from tar sands is responsible for about 17% more carbon pollution than the average U.S. gallon of gasoline. Other studies suggest that numbers could be even higher. To protect our nation from droughts, wildfires, extreme weather, we need to be reducing carbon pollution. But according to the State Department, using tar sands crude from Keystone XL could increase U.S. carbon pollution by up to 20 million metric tons per year. That's why the Keystone Pipeline is a huge step in the wrong direction. My amendment simply holds TransCanada and the tar sands producers accountable for their carbon pollution. It says that they have to reduce other carbon pollution to offset the extra pollution from Keystone XL. This won't get us closer to meeting our climate goals, and building a clean energy future, but at least we won't be increasing the U.S. carbon pollution. This amendment is not a cure-all. Approving Keystone XL will allow the oil industry to triple tar sands production. During the Energy and Commerce Committee hearing on this bill, we heard testimony that there is no plausible scenario in which tar sands production triples and we don't avoid a catastrophic level of climate change. So make no mistake, even with this amendment, the Keystone XL pipeline would be a disaster for the climate. But this amendment would help. It would minimize extra carbon pollution. It would send a message to the tar sands producers and Alberta that they need to do a lot more to address climate change, and it would signal that the United States government takes the threat of climate change seriously. We need to start holding oil executives accountable for the pollution that is threatening our health and welfare. We need to make the polluters accountable for the damage they are inflicting on our children and our grandchildren. Our generation has an obligation to protect the earth for future generations. This amendment is at least a small step in that direction. I urge my colleagues to support this amendment and to vote no on the final bill, and I reserve the balance of our time.
Gentleman from California reserved.
Mr.
Gentleman
Chairman,
from Nebraska.
rise in opposition and claim the time. And,
Gentleman's recognized.
I'll ask the gentleman if he's, did you yield back?
No.
Then I reserve.
The gentleman from Nebraska to reserve.
I'm going to close. I have no other speakers, and so I reserve.
Mr. Chairman, I'd
The
like to
gentleman from
inquire
California has 1 minute remaining.
Who has the right to close on this amendment?
The gentleman from Nebraska has the right to close on this amendment.
Okay. Well, my colleagues, I think that this amendment says if you're going to go ahead with this pipeline, at least look for other ways to reduce carbon emissions. Put the burden on Canada XL, Keystone XL pipeline producers, and Alberta, Canada. Don't just accept all the pollution if it can be minimized by other carbon reductions. That will help reduce the harm that this whole project will cause for the climate change that's threatening us, that we're seeing it today throughout this country, every day in the news. It will help minimize aggravating that problem. It's not a solution, but it's a way that we can say that if we're going to have the XL pipeline, at least get some offsets on carbon so that we're not just increasing it to the maximum levels possible of all the greenhouse gases that are going into the air. So I urge support for this amendment and yield back the balance.
The gentleman's time has expired. The gentleman from Nebraska is recognized.
Thank you, Mr. Chairman. And two realities here. Number one is that on the processes of obtaining the bitumen, the crude that comes will be put into the pipeline, that process is becoming more efficient all the time and decreasing its carbon footprint. But what's produced is equal to a heavy crude. That's what the State Department, under the appropriate rules, stated or concluded based on the environmental impact studies that it's in essence equal to what we're importing from Venezuela today, so it's in essence neutral. Now, that's the State Department's own conclusions and analysis that it would have no real impact on climate change. So the study's been completed, and this amendment's not necessary. It's just another way to keep delaying, and I would request a no vote. Yield back.
Gentleman yields back.
I just yielded back, but if the chair allows me to reclaim.
By unanimous consent, the gentleman may reclaim.
All right.
My question to you is how would this delay the project? It simply says as they develop this pipeline, they have to look for other ways. They can then start figuring that out without delaying the project, as I understand it.
Okay, and we interpreted that requesting that information could be used as a tool to further delay it, and that's how we've reached that conclusion. They've used so many things to delay this already that we're just suspicious that this would be another opportunity. So at that point, I'll yield back. Thank you.
The gentleman yields back. The question is on the amendment offered by the gentleman from California. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the noes have it.
Mr. Chairman, I ask for the yeas and nays.
Does the gentleman ask for a recorded vote?
I ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from California will be postponed. It is now in order to consider Amendment Number 3, printed in House Report 113-88. For what purpose does the gentleman from Georgia seek recognition?
Mr. Speaker, I have an amendment.
The clerk will designate the amendment.
Amendment Number 3, printed in House Report Number 113-88, offered by Mr. Johnson of Georgia.
Pursuant to House Resolution 228, the gentleman from Georgia, Mr. Johnson, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Georgia.
Thank you, Mr. Speaker. This bill is about profits over people. This bill puts Koch brothers' profits above people's health. No one knows how much air pollution this pipeline will cause or how the pollution will impact public health. My amendment, which has been endorsed by the National Resources Defense Council and by the Sierra Club, is common sense. I'm simply requesting a thorough analysis of the potential health risks. I'm essentially asking that analysis be completed before any decision is made on the pipeline. Even though the State Department has submitted 2 environmental impact statements on the Keystone XL pipeline, the Environmental Protection Agency has found that neither statement included a satisfactory evaluation of the increased air pollution that would come as a result of the pipeline's operation. Communities surrounding the oil refineries that would be transporting raw tar sands crude through this proposed pipeline are already exposed to dirty air. Approval of the Keystone XL pipeline will only make it worse. The raw tar sands crude is more toxic and acidic than other types of crude, Mr. Speaker. Raw tar sands crude produces significantly more harmful pollutants and greenhouse gas emissions than conventional crude oil due to the complex refining process it must go through before it reaches the gas pumps. As this type of crude has only been exported to the United States from Canada for a relatively short period of time, there has not been a thorough study on how its transport would affect air quality in our nation. It is troubling that the construction of the Keystone XL pipeline, which would transport 900,000 barrels of this crude oil daily, should take place before such a study that would evaluate its effects on health has ever been done. We have a responsibility to the American people to properly assess what risk the construction of this pipeline may pose to our health. It would be irresponsible of us to sweep these concerns under the rug just to rush this project to the finish line. Valid questions have been raised about the health risks associated with the increased air pollution this pipeline will produce, and these questions deserve legitimate answers. For this reason, I'm requesting that a study on the health impacts of raw tar sands crude pollution, the health impacts of raw tar sands crude pollution in our communities surrounding the refineries where the Keystone XL pipeline will operate. I urge my colleagues to share my commitment to safeguarding Americans' health, and I ask that you approve my amendment and allow for such a study to be done before we make any decision on the pipeline's construction.
Mr. Gentleman, yield back.
I will reserve.
The gentleman reserves. For what purpose does the gentleman from Nebraska rise?
To rise in opposition and claim the time, and I'll reserve.
The gentleman is recognized. Gentleman reserves. The gentleman from Georgia is recognized.
I will yield back.
The gentleman yields back. The gentleman from Nebraska is recognized.
Thank you, and I rise in opposition of this study, and it requires another additional study around the refineries. Keep in mind that the refineries have already been through extensive research and studies to obtain their permits. Yes, the refineries, many of them are expanding right now, also under the tutelage and permitting processes of the EPA. They're already being studied. It's not necessary to then include it as a condition precedent to the construction of the Keystone Pipeline, which is the essence of what this bill does. The gentleman from Georgia mentioned that the two people that are entities that are encouraging this amendment are the two entities that have been at the forefront of causing most of these delays. So it's no surprise to me that the Sierra Club and the NRDC are throwing another tool out there to continue these delays. That's the whole purpose. And after 1,700 days, almost 5 years, 3 major environmental studies on this pipeline, it's time to just get this done. Enough is enough, and I yield back.
Gentleman yields back. The question is on the amendment offered by the gentleman from Georgia. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to. The gentleman from Georgia.
Vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Georgia will be postponed. It is now in order to consider Amendment Number 4, printed in House Report 113-88. For what purpose does the gentleman from Virginia seek recognition? For what purpose does the gentleman from Virginia seek recognition?
I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 4, printed in House Report number 113-88, offered by Mr. Connolly of Virginia.
Pursuant to House Resolution 228, the gentleman from Virginia, Mr. Connolly, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Virginia.
Thank you, Mr. Chairman. I rise in support of this common sense amendment that seeks to protect the pipeline from a possible terrorist attack and to ensure our national security. This simple amendment requests that the Pipeline and Hazardous Materials Safety Administration, in consultation with the Department of Homeland Security, consistent with its existing MOU, conduct a study of the vulnerabilities of the Keystone XL pipeline to a terrorist attack and certify that necessary protections have been put in place. Across the United States, more than 500,000 miles of pipelines transport natural gas, oil, and other hazardous liquids. Within this network, nearly 180,000 miles of pipeline carry hazardous liquids, including more than 75% of our country's crude oil and 60% of all of its petroleum products. This important network connects our power plants, ports, refineries, airports, and military bases. While these pipelines are no doubt critical to the U.S. energy supply, we must also recognize the potential threat. Sadly, as the recent bombing in Boston, my hometown, demonstrated, America must always be on the alert to a terrorist attack on our own soil, sometimes even a native-born one. All it takes is a few bad actors to inflict terrible damage. Unfortunately, our nation's pipelines remain an easy target. Both domestically and globally, pipelines have been a favorite of terrorists. There have been attempted attacks on pipelines throughout the world, including in Colombia, Canada, London, Nigeria, Mexico, to name a few. The Caño Limón oil field in Colombia has been bombed more than 950 times since 1993, for example. Here in the United States, fortunately, we don't face that kind of threat every day, but the threat is still real. Since September 11th, federal authorities have continued to acknowledge that our pipelines are a possible target. In June of 2007, the Department of Justice actually arrested members of another terrorist group planning to attack jet fuel pipelines and storage containers at JFK Airport in New York. In 2011, a U.S. citizen was arrested for planting an improvised explosive device under a pipeline in Oklahoma. And in June of 2012, a man was arrested for trying to blow up a pipeline in Texas. Even a single individual with a grudge can wreak havoc with a pipeline and cause substantial harm. In 2001, a vandal armed with a high-powered rifle shot a section of the Trans-Alaska pipeline, causing extensive economic and environmental damage. Recognizing that this threat is real, my simple amendment asks that the Pipeline and Hazardous Materials Administration work with Homeland Security to study the vulnerabilities of the Keystone Pipeline and certify the protections are put in place to withstand such attacks. If constructed, the Keystone will represent a 1,700-mile target. The very least we can do, if we're going to do that, is to ensure we have protections in place to protect both the source of our energy and our national security, and I reserve the balance of my time.
For what purpose does the gentleman from Pennsylvania rise?
I rise in opposition to this amendment.
The gentleman is recognized.
I do rise in opposition to the amendment. My good friend from Virginia, I understand his need to make sure that our pipelines are safe, but this amendment is redundant of existing Transportation Security Administration guidelines. It's unnecessary and simply attempts to further delay the project. TSA guidelines bring a risk-based approach to the application of the security measures throughout the pipeline industry. As stated in the National Infrastructure Protection Plan, DHS assesses risk as a function of threats, vulnerabilities, and consequences. With this in mind, the most effective security programs employ a risk management process that facilitates protective planning and decision-making to migrate the risk for pipeline assets. The operator's risk assessment methodology is subject to review by the TSA. Therefore, risk and vulnerabilities of pipelines are already covered under current guidelines. There is no need to specifically single out this pipeline for further study. Clearly, this is intended to delay Keystone Pipeline from being built, so I urge a no vote and yield back the balance of my time.
The gentleman yields back. The gentleman from Virginia is recognized. He has a minute and a half.
I thank the Chair. And I would simply say in response to my friend from Pennsylvania, for whom I have great respect, that the review process is not redundant, because the review process looks at a lot of things: stress corrosion, improper operation, weather-related disaster, even vandalism. It does not, however, address acts of terrorism. And that's why I do not believe that my amendment is redundant. And frankly, in light of recent events in this country, we must double-check and be double sure that that which we build, as sensitive as a pipeline, is secure. And I think Americans are entitled to that extra security. I don't consider it a redundancy, and I urge passage of the amendment. And with that, I yield back, Mr. Chairman.
The gentleman yields back. The question is on the amendment offered by the gentleman from Virginia. Those in favor say aye. Aye. Those opposed say no. No. In opinion of the Chair, the noes have it. The amendment is not agreed
Mr. Chairman?
to. The gentleman from Virginia.
On that matter, I would ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Virginia will be postponed. It is now in order to consider Amendment Number 5, printed in House Report 113-88. For what purpose does the gentleman from West Virginia seek recognition?
Mr. Chairman, I have an amendment that's designated as Amendment Number 5 in the rule.
The clerk will designate the amendment.
Amendment Number 5, printed in House Report Number 113-88, offered by Mr. Rahall of West Virginia.
Pursuant to House Resolution 228, the gentleman from West Virginia, Mr. Rahall, and a member opposed, each will control 5 minutes. The Chair recognizes the gentleman from West Virginia.
Mr. Chairman, I'm offering this amendment on behalf of myself and Peter DeFazio of Oregon. This amendment simply strikes Section 3 of the bill, This is a section which states that the Keystone XL pipeline does not require a permit to cross the international border between Canada and the United States. Under this amendment, all other provisions of the bill remain intact, including those relating to judicial review, rights of way, and the Clean Water Act. I believe that getting into the business of waiving permits for a foreign company to do business here in the United States is not the way to facilitate the construction of this pipeline. American interests are at stake here, and to allow this extensive, massive pipeline project to proceed with a permit is ludicrous. As I said in comments earlier today, we do not even do that for domestic companies here in this country. Section 3 also creates a very convoluted and confusing regime. It references a final environmental impact statement issued on August 26, 2011 as satisfying NEPA for the project. Yet that EIS was done for a different permit application than the one currently pending. I repeat, that EIS was done for a different permit application than the one that's currently pending. In February 2012, TransCanada split the project into two pieces, a northern route and a southern route. The company then, on May 4, 2012, reapplied for a permit for the revised route, limiting it to the northern route that is the subject of H.R. 3. Yet the pending legislation references an EIS from August 2011, again for an entirely different permit application. As a supporter of the Keystone Pipeline, I find it difficult to see how this convoluted process set forth in Section 3 would facilitate the construction. I reserve the balance of my time.
The gentleman from West Virginia reserves. Does the gentleman from California rise?
Mr. Chairman, I rise to claim time in opposition of the amendment and yield 2 minutes to the gentleman from Nebraska, Mr. Terry.
Thank you. And
the gentleman from Nebraska is recognized.
I want to clarify that that was done for a different permit. The study that was done that's referenced in there is the environmental study and the requested supplemental for the route except for the state of Nebraska. There's another sentence in there that he didn't mention, and that the now second supplemental for the state of Nebraska new review, there was an earlier statement that there was never one done on the Nebraska. That's just absolutely false. So the reality is we've done all of the environmental statements on this route for this permit that were required. So I want to make that clear. And the other point that I'd like to make is the language that's taken in this bill about deeming it in the national interest and deeming the environmental studies as they've been done for this route in total have been done before, including to the language taken out of a bill that the gentleman that's speaking right now supported in 2004, and I yield back my time.
The gentleman from California is recognized.
Reserve the balance of my time.
The gentleman from California reserves. The gentleman from West Virginia.
Mr. Chairman, I appreciate the gentleman from Nebraska's comments. I understand the EIS to which he refers was done for the state of Nebraska, but not for the current pending application. I yield the balance of my time to the co-sponsor of the amendment, the gentleman from Oregon, Mr. DeFazio.
The gentleman from Oregon is recognized for 3 minutes.
I thank the gentleman for yielding on this. You know, I spoke earlier today. This is the 7th attempt by this House to expedite, or now, in this case, we're not expediting permitting. We are mandating permitting. Now, the gentleman just said that, you know, that there's some disagreement here. The bill clearly states that it's the 2011 DEIS, which is deemed to be sufficient, which does not contain the current routing for the line. I mean, we could create somewhat of an extraordinary precedent here. We could just have one generic national pipeline EIS that was done somewhere for something and went through the process and was approved, and then deem that any other pipeline that wants to be built can use that generic pipeline permit. That would certainly expedite things. Would that protect the public? No, I'm sorry, I don't have enough time. But no, I'm sorry, I don't have enough time. I don't.
Well, that'd be correct.
Yeah, well, and that, you know, we would just deem that pipelines anywhere and everywhere met national interest, public safety, and that. I also raised the point earlier that this will transport tar sands oil through a pipeline which the IRS has deemed not to be oil, so it won't pay the normal excise tax to go to the trust fund, which takes care of leaks like the one we just recently had in Kansas. It will go to a tax-free export zone to a refinery half owned by Saudi Arabia and this will bring us energy independence. Independence from whom? You know, every time we pump up another barrel, the Saudis and OPEC drop a barrel. They're keeping the price up. There's no free market in oil. You guys all know that. This is not going to save Americans 1 penny at the pump. If you want to stop, save Americans money at the pump, let's go after the speculators on Wall Street who are adding 75 cents or $1 to the price of a gallon of gas. Let's go after the collusion by the oil companies who shut down all the refineries all at once every year at the beginning of the refining season for periodic maintenance, which they couldn't predict was going to happen, or sometimes there's a little accident. Except it turned out last year with an investigation they weren't really shut down. They just jacked up the price 50 cents a gallon like they always do in May, and just like they did 2 weeks ago. So to pretend that somehow by deeming this to be sufficient, mandating it happen, allowing a foreign company to build this pipeline across the United States of America, transport tar sands oil to a refinery half owned by the Saudis to be exported out of the United States, perhaps to China. Over there you're saying, oh, we don't want to go to China. Well, it may well go to China. Go through the Panama Canal. You're not going to stop that. And is going to save the American taxpayers money at the pump and put people to work. Yes, there will be temporary construction jobs, but we can do better, particularly as this committee. If we made the investments we need to make in our water infrastructure, our port infrastructure, our roads, bridges, highways, and transit systems, we could put millions of people to work permanently in this country and rebuild our infrastructure and once again claim world leadership there. We got better things for this committee to be doing.
The gentleman's time has expired. The gentleman from California is recognized for 4 minutes.
Mr. Chairman, this amendment guts the bill by eliminating the section that 1, declares that no presidential permit is needed for TransCanada's Keystone XL pipeline, and 2, deems the lengthy environmental reviews already completed as satisfying the requirements of national EPA and the National Historic Preservation. Given that this project has already had 5 years of studying, Section 3 is necessary to ensure the Keystone XL project is done in a timely manner, and we need these American jobs. I yield the balance of the time to Chairman of the full Transportation Infrastructure Committee from Pennsylvania, Mr. Schuster.
The gentleman from Pennsylvania is recognized.
Thank you, Mr. Chairman. Thank you, Mr. Denham. My good friend from Oregon is right about this committee building infrastructure, but there's nothing more important right now than making sure our pipelines are in place to bring the energy safely to millions of Americans and efficiently to millions of Americans. So this is a core of what this committee does. That's why we have primary jurisdiction. That's why we're here debating this issue today. But this bill simply takes back congressional authority, constitutional congressional authority, for us to be able to pass legislation to move things forward, and in this case, to move this pipeline forward. This process was set up by an executive order taking away congressional authority. So I am very, very proud and pleased to stand here today and to urge my colleagues to take a vote today to take back part of our constitutional congressional authority, move this pipeline forward, creating jobs and giving us more energy security in the world. And with that, I yield back to the
gentleman from California is recognized.
Urge a no vote and yield back the balance of my time.
The gentleman yields back. The question is on the amendment offered by the gentleman from West Virginia. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to.
Mr. Chairman, ask for the yeas and nays. Recorded vote.
Recorded vote?
Yes.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from West Virginia will be postponed. It is now in order to consider Amendment Number 6, printed in House Report 113-88. For what purpose does the gentlewoman from Connecticut seek recognition?
Mr. Speaker, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 6, printed in House Report number 113-88, offered by Ms. Esty of Connecticut.
Pursuant to House Resolution 228, the gentlewoman from Connecticut, Ms. Esty, and a member opposed will each control 5 minutes. The chair recognizes the gentlewoman from Connecticut.
Thank you, and I yield myself 2 minutes. My amendment would strike the words operation and maintenance from Section 7 of the bill. This section requires the Army Corps of Engineers to approve all permits under Section 404 of the Clean Water Act and Section 10 of the Rivers and Harbors Act within 90 days of receipt of a permit application. To mandate approval of all permits would apply regardless of whether the project meets the needs of the law or not, and would cover not only the initial construction of the project, but takes the unprecedented step of applying to all future operation and maintenance in perpetuity. Not only is this unprecedented, it is unwarranted and reckless. Each time the House has debated the Keystone XL pipeline, the focus has always been on expediting the construction. This amendment does not affect or delay construction. I repeat, this amendment does not affect or delay construction of the pipeline, whether you support the pipeline or not. Section 7 goes far beyond that. It would require the Corps to grant any permit request for operation and maintenance of the pipeline for all eternity. We do not provide this special treatment to any other pipeline operator in the U.S. Domestic companies are required to go through the proper process for obtaining permits for construction, operation, and maintenance activities. Why would we treat a foreign company differently and give them a free pass through a multi-decade lifespan of the pipeline? My amendment would eliminate this reckless loophole and a few others to ensure that all operation and maintenance activities on this pipeline, should it be built, are subject to the same review and mitigation requirements that the other 2.6 million miles of pipeline in the United States must meet. I urge members to support this amendment, and I reserve the balance of my time.
Gentleman from Connecticut, the gentlelady from Connecticut reserves. For what purpose the gentleman from California rise?
Mr. Chairman, I claim time in opposition to the amendment.
The gentleman from California is recognized.
This amendment would further delay the Keystone XL pipeline and create additional uncertainty for the project. This amendment would basically gut the bill by allowing the construction but not the operation of the pipeline. It makes absolutely no sense for the federal government to permit a project to be constructed but not operated. This would be like getting a building permit to construct a house but not being able to certify the occupancy to actually live in the house. This pipeline will be subject to continued oversight by the Pipeline and Hazardous Materials Safety Administration, the Corps, and other regulators to ensure that the operators are complying with the project's permit requirements. I reserve the balance of my time.
The gentleman from California reserves. The gentlelady from Connecticut is recognized.
I now yield 1 minute to my colleague, distinguished gentleman from Illinois, Mr. Lipinski.
The gentleman from Illinois is recognized.
I thank Ms. Esty for yielding, for offering this amendment. I've always been a supporter of Keystone XL Pipeline. I have voted for it every time it has come to this floor in any form that has come here. This, however, this bill goes beyond simply completing the environmental review and presidential approval of the pipeline. The bill mandates that the Army Corps and other agencies approve permits not just for construction, but for all future maintenance activities on the pipeline. Army Corps review of permits is important to limiting environmental damage and other impacts like flooding. The southern portion of this pipeline, which I'm very happy is underway, is currently being constructed without having to waive laws and automatically approve permits like this. I urge members to support this amendment, and we can really come together in a strong bipartisan fashion to approve the Keystone XL pipeline, get this done, and get these jobs created in America. Now I yield back.
The gentleman yields back. The gentleman from California is recognized.
Mr. Chairman, reserve the balance of my time.
The gentleman from California reserves. The gentlelady from Connecticut is recognized.
I yield myself such time as I may consume. When a version of this amendment was offered in committee, the majority opposed it, claiming that the Corps permits are intended to cover both the construction and the ongoing operation and maintenance of a project. This is simply not accurate. Following the markup, I consulted with the Army Corps, which stated very clearly that ongoing operation and maintenance activities beyond the initial 5 years are not authorized under the initial permit for construction of the project. In fact, according to the Corps, operations and maintenance activities that occur in the future beyond the initial 5 years need to be authorized under a separate permit at the time the activity takes place. In addition, any permit that is issued today by the Corps for construction or maintenance would expire in 5 years and need to be renewed. And I have a copy of the Army Corps' explanatory decision document, Nationwide Permit 12, describing the permitting procedures, and I ask unanimous consent that it be entered into the record. So the language in the underlying bill would give construction at all future operation and maintenance under the Clean Water Act and the Rivers and Harbors Act get a free pass from review by requiring the Corps to approve them, regardless of whether they minimize or mitigate the impacts. In addition, this amendment would eliminate another loophole to ensure that operation and maintenance activities comply with the Endangered Species Act, just like all other pipelines. Further, the amendment would strike maintenance from Section 4 on judicial review to prevent a small family farmer or a property owner from being forced to travel to a D.C. court to seek redress from future harm to their land or to their children's rights for the duration of the lifespan of this pipeline. Regardless of your views on the construction of the Keystone XL pipeline, I urge my colleagues to vote yes on my common sense amendment to prevent new loopholes and quite possibly to prevent the creation of a regulatory earmark for one foreign corporation. I urge a yes vote on my amendment, and I yield back my time.
The gentlelady's previous request will be covered by general leave, and the gentlelady yields back. The gentleman from California, for what purpose does he rise?
Rise to closing remarks, Mr. Chairman. Yield the gentleman from Pennsylvania, Mr. Schuster, the balance of my time.
The gentleman from Pennsylvania is recognized.
I thank the gentleman, I thank the chairman, and I thank the gentleman for yielding. Once again, this amendment is nothing more than to delay or gut the bill, and it is correct what the gentlelady from Connecticut says, that this amendment does not impact the construction at all. It does not. But as the gentleman from California pointed out, and I think all those that are listening to debate today, this is the analogy here is if you build a house, this amendment would say you can't live in the house. You can't operate in the house. So again, this amendment is nothing more than gutting the bill. It's a delay tactic. And as I said earlier, this bill allows Congress to regain its constitutional congressional authority, and Congress has the expressed authority under Article 1, Section 8 of the U.S. Constitution, and I quote, to regulate commerce with foreign nations and among the several states. So this bill does that. I urge all my colleagues to vote no on this amendment and yes on the underlying bill, and with that I yield back the balance of my time.
The gentleman yields back. The gentleman from California.
Yield back.
The gentleman from California yields back. The question is on the amendment offered by the gentlelady from Connecticut. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to.
I request a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentlelady from Connecticut will be postponed.
Thank you.
It is now in order to consider Amendment Number 7, printed in House Report 113-88. For what purpose does the gentlewoman from Texas seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 7, printed in House Report number 113-88, offered by Ms. Jackson Lee of Texas.
Pursuant to House Resolution 228, the gentlelady from Texas, Ms. Jackson Lee, and a member opposed will each control 5 minutes. The chair recognizes the gentlelady from Texas.
I thank the chairman very much, and I thank the respective authors of this legislation because I know that their intent is a purposeful intent, and I have made public statements that I believe that the moving forward with the right approach, ensuring that the necessary protections are in place, the necessary environmental protections are in place, and permitting is in place, will create an enormous amount of jobs. In fact, I oppose the rule because I had offered amendments that would provide opportunities for minority contractors, women-owned contractors, opportunities for recruitment of a new generation of workers in the energy industry, which I thought would be a contributing factor to this legislation. But I offer a very simple amendment that has nothing to do with stopping any aspect of the construction. I would hope, however, that the regular order would proceed with the State Department's permitting process and the President's approval. But my amendment does not speak to that. My amendment is an amendment that seeks to simply be fair, Mr. Chairman. My amendment is simple, straightforward. It extends the time period for filing a claim arising under the Act from 60 days to 1 year after the date of the decision or action giving rise to the claim. This amendment is especially needed because H.R. 3, the underlying bill, vests exclusive jurisdiction over any and all claims arising under the Act in a single court, the U.S. Circuit Court of Appeals for the District of Columbia. thousands of miles from many of those who may be impacted. Think about that. The Keystone Pipeline is proposed to run from Alberta, Canada, through the great states of North Dakota, South Dakota, Nebraska, Kansas, Oklahoma, and my state of Texas, and all the way to the Gulf. And maybe there is some collateral impact as well. And the only court in the country authorized to hear the claims of any resident of any of these states who seek justice for a legally cognizable claim or injury is located more than 1,000 miles away from their homes. Mr. Chairman, they cannot go to a district court. They cannot go to the Southern District. This will impose an undue hardship and financial burdens on ordinary Americans seeking justice. Instead, the bill requires them to find and retain a high-priced D.C. lawyer that they don't know, may have never met, to represent their interests in a court far, far away. Another reason for extending the time period in which to file, remember, this is after the passage, construction of this particular entity, to file a claim from 60 days to 1 year, because by lodging jurisdiction in D.C. Court of Appeals, the burden of proof and persuasion is shifted from the governmental and corporate actors involved to the homeowners, small businesses, individuals bringing legal rights, grandma, grandpa, and all of those individuals will have to travel 1,000 miles. This is because the burden that must be shouldered by a plaintiff is very steep. To challenge factual and evidentiary determinations made in an environmental impact statement, for example, a plaintiff must demonstrate that they are not supported by substantial evidence in the record considered as a whole. To meet the standard, plaintiffs will have to retain experts, locate and prepare witnesses, and gather and review documentary materials. I'm going to reserve my time at this time, but I will say I hope in a bipartisan way we can get to where all of us would like to be, ensuring that we have a constructive project for all Americans. I reserve my time.
Gentlelady reserves her time. For what purpose does the gentleman seek time?
Mr. Chairman, I claim time in opposition to the amendment.
Gentleman is recognized.
I reserve the balance of my time.
I reserve.
Gentlelady reserves. Who seeks time? Gentleman
I will reserve for my close, Mr. Chair.
Gentleman from California reserves his time to close.
Does the gentleman have any other speakers? Excuse me, Mr.
Gentleman from California has the right to close.
And does the gentleman have any other speakers but himself?
Gentleman have any other speakers?
I am reserving for my personal close.
Gentleman is reserving to close.
And he has no other speakers. Is that correct, Mr. Speaker? Mr. Chairman? Does he have he has no other speakers but himself? And he's
the gentleman has indicated that he is reserving the time for his own closing.
Thank you very much. My friends, again, I would have hoped, having worked with the gentleman from Nebraska, the proponent of this legislation, that we would continue to walk in a bipartisan pathway. This amendment is to relieve the burden on some of the very people many of us represent, and that is, of course, those individual claimants who happen to be in faraway places who now have to go to the D.C. Court of Appeals and to actually bear the burden of responsibility dealing with when you challenge the factual and evidentiary determinations made in an EIS statement, environmental statement, for example. The plaintiffs must demonstrate that they are not supported by substantial evidence in the record considered as a whole. That's an extreme burden that will have to be offered by plaintiffs. They'll have to secure lawyers here in the D.C. area. They'll have to travel here, bear extra expenses. It will be the necessary to get experts, locate, prepare witnesses, and even relocate themselves, gather and review documentary materials, and I would suggest that it is obviously a stress and a burden. This bill has, in Section 4, no right to judicial review. So in essence, it means that you have one track to go in for a number of issues that might come forward. I am concerned that that would be the case, and for that reason, I think that our amendment has the strength of purpose that is necessary. Let me also add, again, if I want to be very clear, why should we burden the plaintiffs, individual plaintiffs, Mr. Chairman, with financial burdens that are excessive? My amendment gives them a fair amount of time to get a response and to participate in this process. I ask my colleagues to support the amendment, and I yield back my time.
Gentlelady's time has expired. Gentleman from California is recognized.
Thank you, Mr. Chairman. This amendment seeks to undermine an important streamlining provision in the bill that sets firm deadlines for filing claims. In order to cause maximum delays, opponents of projects often wait until the final possible day to file claims. Setting firm, reasonable deadlines has no impact on legal rights. This bill is limited to in the types of claims that receive the expedited review to just 3: validity of final orders, constitutionality of the act, adequacy of the environmental impact statement. These claims must be filed within 60 days of the final order or action giving rise to that claim. No other claim is affected by the 60-day filing deadline. Because of the limitations on types of claims covered by the deadline, 2 months is more than ample time to file with the D.C. Circuit. Extending to a year is simply one more delay tactic. I urge a no vote and yield back the balance of my time.
Gentleman yields back his time. The question is on the amendment offered by the gentlelady from Texas. Those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to. Gentlelady from Texas.
I request a recorded vote.
Gentlelady from Texas, pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentlelady from Texas will be postponed. It is now in order to consider Amendment Number 8, printed in House Report